All right. I think that we are going to get a ruling on this quote unquote gag order. You all know I don't like that word, but I think we're going to get a ruling on it very soon. We might get it while we're on the air here. So this has been a fascinating morning for those of you who have been following along. I will just tell you that I think Judge Chutkan is having none of it. So let's just say our hellos as usual. Good morning to everyone. I'm watching you all. Boston, Santa Fe, Bangkok, Toledo, Berkeley, Tigard, Oregon. Am I pronouncing that right? Oklahoma. Hi, everybody. We've got an enormous amount of people watching live already. Good to see you. I am Elizabeth Cronise McLaughlin, also known as ECM. This is Resistance Live for the 16th of October, 2023. And as always, for our visually challenged viewers, I am wearing a black sort of like boat neck. It's not actually boat neck. It's just like a regular crew collared sweater today. My hair is down. I am dirty blonde, pink skin, green-eyed woman. I'm coming to you, as always, from occupied Tongva land here in Southern California. And my pronouns are she, her. Okay, it has been a very dynamic morning already on the legal front. And I'm just going to kick it off by talking about this hearing that is ongoing in Judge Chutkan's courtroom. She conveniently took a break right as we were about to go live. So right now we're sort of waiting to see what happens next. But this has been the hearing on whether or not an order should issue limiting what Trump can say about the trial, the witnesses, the judge, the prosecutors in the case that is currently pending before Judge Chutkan in the District Court for the District of Columbia concerning his conduct related to January 6th. Okay, so one of the things that has been just so fascinating about this hearing this morning is watching the live stream of, and it's not like live streaming on video, but there are reporters in the courtroom who are reporting minute by minute on the statements that are taking place in the court. And it is very clear from that reporting that Judge Chutkan is over it. She is over the way in which Donald Trump has been threatening prosecutors, threatening court staff, making extrajudicial statements about the prosecution of crimes against him, about Jack Smith's wife, statements that have been made about witnesses, Bill Barr, General Milley, all of this. She's really, really, really done. And the clear question now, and what we're waiting to hear about at this moment, is not whether or not there's going to be an order, because it's very, very clear from the scope of what has happened this morning that there is going to be an order, and we actually might hear about it like from the bench, which is not what I was expecting. I was expecting that we were going to have a written order, and we'll probably get a written order, honestly, to follow it. There's plenty of times where a judge will rule from the bench and then issue a written order after the fact. But we're in a situation right now where she's really done. She has asked questions from the bench this morning that are things like, tell me why he's allowed to call the prosecutor a thug and still be walking around the streets. Because we all know that if it was any other person, he wouldn't be, right? Things like that. Now, I'm paraphrasing, but she literally said, why do you think he, unlike any other defendant, should be able to call the prosecutor a thug and remain on the streets? Remain on the streets were words that she literally said. And she's also read out loud into the record his many threats against Bill Barr, General Milley, other witnesses, his statements about Jack Smith's wife making donations to Democratic campaigns, saying that, do you think it's okay for General Milley to be executed? Right before she took this recess, she asked if the comments that had been made about Bill Barr being called a slimy liar were appropriate. I have to say that in watching the responses to all of this by Attorney Lauro, who of course represents Donald Trump, I have, as I've been live threading this, been completely appalled, honestly, by his response. So to the Bill Barr comment, his response was, well, the truth is a defense. It's not actually in this circumstance. He's made tons of comments about how this is a political prosecution, about how his client is being persecuted, about the fact that, this isn't like any other case. He shouldn't be treated like any other case. He's running for president. All of these statements that fundamentally defy the constitutional provisions first of all, of the First Amendment, because he's making all sorts of statements about the First Amendment that are not legitimate under law, but also that fundamentally defy an underlying principle of our entire judicial system, not often applied. I'll just be fair about it, but that no one is supposed to be above the law. And the arguments that he's making to that effect are fundamentally that because Donald Trump is running for re-election, he should be allowed to say whatever he wants. Now, one of the more interesting aspects of this hearing has been watching the prosecution try to slice this in a way that allows Donald Trump to make statements related to the election that simultaneously do not interfere with this prosecution, the jury pool, the judge, the prosecutors, the witnesses. So one of the examples that was given is that Trump should be allowed to call Joe Biden crooked Joe Biden. But is he allowed to say that crooked Joe Biden is engaging in a political prosecution through the DOJ? No, that would be a violation of any potential quote unquote gag order. Again, I got to remind everybody, the reason why I don't like the gag order language and the reason why I've really advocated against using it is because what we're talking about here is an order that limits Trump's extrajudicial statements. It doesn't gag him, right? It doesn't stop him from saying anything publicly. It doesn't arbitrarily limit his First Amendment rights. And in fact, the motion that was filed by Jack Smith's team is pursuant to a local criminal procedure rule in the District Court for the District of Columbia that allows the limitation of certain kinds of prosecutorial interference statements outside of the court. So this judge has been really adamant this morning that, she's not going to let this fly any longer. I think the real question now is to what extent? And the reason why she just took the recess was because Laura said, are you seriously considering throwing him in prison if he violates a gag order in the middle of a presidential election? And I have to say that, that argument in and of itself is one that I don't even think holds water, because the thing that should be happening is that anybody who's running for president, who is under criminal prosecution, who is being prosecuted, who's under indictment, should be able to control themselves in terms of what they say. And honestly, these boundaries are not that hard to navigate. You can criticize someone who you're running against for elected office without threatening them with violence. You can criticize someone who you're running against in an election without threatening the witnesses or the prosecutor or the judge who are overseeing or involved in your criminal prosecution, right? These are not hard things to demarcate. And so the idea that that somehow this is all going to stop him from being able to run for re-election is false. And honestly, like if he could just control himself, the threat of him being thrown in jail would not be real. So I think that it's very clear what direction she's going to go in here. And I think the question is just exactly what the demarcation is going to be. But she's really holding Trump and his attorney's feet to the fire this morning. She's not having any of this. And, to the point where when the judge made an argument when Laura made an argument that, that he thought the limitations that had already been put on Trump were functioning fine, she laughed at him. She laughed. And one of the things that I said on Threads this morning, which I just want to reiterate here, is there's lots of ways in which you could, as an attorney in this situation, have made very different arguments that might have worked out differently for your client. You could have said, you know what, Your Honor, heat of the moment, my client made some statements that he shouldn't have made. And we apologize to the court. We apologize to the prosecutors. We obviously understand the court's very significant interest in making sure that the jury pool isn't poisoned and the witnesses are safe. And I can assure you that I have had the strongest conversation possible with my client. He will not be making any statements like this again, Your Honor. We understand the concern, but we're going to make certain that our client sticks to the requirement of not further engaging in this kind of conduct. All right. You could have made that argument. Now, I know that Trump can't keep his mouth shut. We're saying all of this in the context of him being a malignant narcissist with sociopathic tendencies, and we all know who we're dealing with, right? But as an attorney in a courtroom facing this kind of thing, the legal strategy could have looked very different. And that is not what Lauro decided to do. In fact, what he decided to do instead was repeat lines that have been in Trump's own fundraising emails about this entire situation that are a part of the concern here about the statements that Trump has made. So in essence, Trump's lawyer has dug the hole further through his arguments today. He really hasn't done anything to kind of ameliorate the circumstances. So, we're in a situation here where I don't think Judge Chutkan's going to have much of a choice. And I think we're very much in a situation where the expectation here is that there's going to be an order and it's going to be pretty strong. I'm just seeing an update on the live stream here from the New York Times reporters. And so I'm doing this with you guys all in real time. I want to make sure that we're not missing anything. And it looks like we haven't yet. It looks like she still hasn't come back to the bench. So I've got my camera like slightly in the way here. So I'm just going to turn that to the side. So she's not back on the bench yet. They're doing reporting on this, and we'll see what happens. There was one other ruling that she did make this morning, and this one is kind of like less surprising. This one actually goes in favor of Trump, where not really in favor of him, but she's going to allow the defense to poll residents of the District of Columbia about their opinions on the case. And the reason why she's going to allow that, now we don't know, there will likely be some limitations on that. They're not going to be able to go out and make wild accusations that would arguably poison the jury pool. But she is going to allow them to at least poll the community. And there's a legitimate reason for that, which is that, there is this issue of, can he get a fair trial in DC? Now, of course, everybody knows he can get a fair trial in DC. I don't think that's really the issue. Like, you're not entitled to a jury of 12 people who think that you should be reelected and that you didn't violate the Constitution. You are, however, entitled to conduct limited inquiry into whether or not the jury pool has already been poisoned against you. And so it sounds like she's going to allow that. This was a part of one of the motions that had been filed by Jack Smith's team, and they had requested certain limitations on what could be asked. We don't know the degree to which this is going to go yet, but that has already been ruled upon from the bench. So right now we're just waiting for this issue of what's Trump going to be allowed to say? And if he violates that, is he going to go to jail? I have to say that it sounds to me like she's already really very, 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 very done. So again, very exciting morning in the district court for the District of Columbia. I'm kind of halfway hoping actually that we're going to get a ruling from the bench while we're on the air, so I don't have to come back on and talk about it later. Although I know you guys like your double broadcast from me. Reminder, if you like what you're getting here today, please don't forget to like this broadcast. Please don't forget to subscribe to the channel. We're here every day at 9 a.m. Pacific, 12 noon Eastern live. As always, I appreciate your comments and I appreciate your support. You can share it with all your friends if you're interested in the summary of what's going on. Okay, while we wait, let's talk about a couple of other things that are going on. This morning in Fulton County, Georgia, simultaneously, there is a hearing going on the jury questionnaires that have been proposed by the defense and the prosecution in the trial of Ken Chesebro and Sidney Powell. Reminder, that trial starts a week from today, just in case you thought we weren't busy enough. So we're at it. We're in a moment where we're about to be having overlapping trials, and Trump's trial in New York State is still ongoing. Okay. It's a fascinating moment. The hearing about the jury questionnaires is to determine what's going to be in the written questionnaires that are going to be given to the prospective jurors in the Chesebro-Powell case. And we don't know the scope of what those are going to contain yet, but we do know that 450 potential jurors are being called to the court on Friday to begin filling out these questionnaires. 450. Now, if a jury can be seated from that initial pool, that will be the end of it. If not, there's another 450 because they called 900 prospective jurors for this case. There will be another 450 who are similarly polled. And we can expect that jury voir dire is going to start fast and furious on Monday morning. That is the process by which the prosecution, the defense, and the judge, to be fair about it, determine whether or not someone is qualified to be a juror in the case. But we are heading right into really, really fascinating times in what I have been referring to all along as hot accountability fall. So one thing I want everybody to be aware of is that, as we are doing these overlapping trials, of course, I'm going to be here every day kind of giving you guys the lowdown on what's going on. And if necessary, we will be doing multiple broadcasts today to make sure that we cover it, because I know you're all kind of fascinated by this. I'm going to remind everybody as well that if you have questions as all of this is ongoing, you can become a paid subscriber over at patreon.com/resistance-live and get on our question feed to ask questions 2 hours before every broadcast. The exception being emergency broadcasts, which I usually give somewhere between an hour to half an hour's notice on. All right. But our subscription started as little as $2 a month. And if you think you're going to have questions and you want to ask questions, you should head on over there. And Also, even if you don't, financial support for this work, which is a lot of effort for all of our work here, it would be very helpful. All right, so let's talk about a couple of other things that are going on. House of Representatives. Woo! Oh my goodness. Okay, so Jim Jordan, Steve Scalise dropped out. We talked about that on Friday's broadcast. You can go back and watch it if you would care to. Jim Jordan is now arguably, I guess, the front runner for the Speaker of the House, but he is way, way short of the necessary votes, like over 50 as of Friday night. Some very strange things have happened over the weekend on this front, of which people should be aware. Namely that Jim Jordan and his good buddy Sean Hannity have been involved in a pressure campaign on more quote unquote moderate Republicans. Again, I have to say this all over and over and over again, that when I say moderate Republicans, what I mean are Republicans who are elected from districts that Biden won in 2020. Okay. So they are accountable to constituents who are largely blue. All right. And that in and of itself raises very interesting questions about how they're going to explain their votes for Speaker of the House to their own constituents. And they are among the folks that people have been, suggesting should potentially be supporting Hakeem Jeffries here. So this pressure campaign that was initiated by like Jim Jordan and Sean Hannity has already been made public because some of these emails that were being sent by Hannity's staff have now made their way into mainstream media reporting. And what they say is, we want to know if you're going to support Jim Jordan. And if you're not, we want to know how you could possibly justify that decision. The language is really strong and inappropriate. And I'm going to say that the reporting so far has been that this is actually backfiring on Jim Jordan, that it has made these quote unquote moderate Republicans dig their heels in even further, that they are not voting for him. So we are expecting that there is going to be a vote tomorrow, and that it's going to fail, that Jim Jordan is not going to be elected. There is some noise this morning about some Republicans having approached Democrats with a proposal that would allow the Speaker pro tem right now, who is Patrick McHenry, who he doesn't have the official duties or capabilities of an elected Speaker of the House. There's been a proposal made to give him a little bit more authority to, say, bring bills to the floor of the House, so the floor of the House isn't completely stopped in its functionality. That is not something that I expect that the Democrats are going to agree to. And Hakeem Jeffries and a whole host of Democrats, if you've been paying attention, have been saying over the weekend and really through last week that, Jeffries is the solution. They've got a 212 vote quorum right now that will support him. And all they need is 5 Republicans to come to their senses and vote for Jeffries so that the House can get back to business and a bipartisan coalition can be built. It's really, really, really a very strong argument at this point, and I don't think it's unreasonable. So we'll have to see how this shakes out, but that's underway as well. All right, Judge Chutkan is apparently back on the bench while we are live. So let's see what's going on here. Okay, I am not seeing any reporting right now yet on the live stream that is coming out of the courtroom. But if she is back on the bench, I'm sure we're going to hear something very soon. So she's going to grant in part and deny in part the motion to restrict the out-of-court statements, according to somebody in our comments right now. Let me just see if we can get a little bit more detail on this right now in terms of what's coming out, because I'd love to give you guys live on the fly reaction. Okay, let's see what we've got. Nothing yet on the New York Times feed. All right, so we'll stay tuned to that, and I will make sure that I'm glad this is happening in real time, because I want you guys to know how we can interpret the kind of details of this. All right, my suspicion is that she's going to grant anything that relates to threats. Obviously, that makes a lot of sense, that he can't threaten the prosecutors, he can't threaten the judge, but we'll see what the details are here. And if she's reading a ruling from the bench, here we go. We've got updates. Okay, let's just see what this says now. Chutkan has returned is what they're reporting, and we'll see what the details are. All right, so stay tuned on that. Okay, I did have a question this morning while we're waiting for additional details, which I'm not going to go off the air until we cover, don't worry, about the state of the International Criminal Court versus what is happening in Palestine and Israel. So And these are very good questions that folks have asked about the jurisdiction of the International Criminal Court. So Israel is not a member of the ICC, much like the United States, okay? But the prosecutor of the ICC has stated that because the ICC had historically granted jurisdiction over Palestine, they are going to exercise jurisdiction over everything that happens in the Gaza Strip, both with regard to Israel and actions of Hamas that have been terroristic toward Israel, as well as Israel's own conduct in relation to what's happening in Gaza. So the International Criminal Court is going, it seems, to be investigating the conduct on both sides here with regard to what's going on. And I think that's very, very necessary. Those of you who are curious about how human rights law applies in these situations, I did a very extended broadcast on that on Friday. And you can go back and watch it. All right. Okay, so Judge Chutkan won't stop Trump from criticizing the residents of the District of Columbia or the government in broadly construed statements. But she is going to issue what she is referring to as a narrowly tailored gag order on Trump. All right. So I will tell you that I am not surprised about this issue of DC. One of the things that I had always thought about this particular motion was that the idea that you couldn't claim that you can't get a fair trial in a particular jurisdiction was actually not the worst of the conduct that Trump had engaged in. And it seems to me that, the other thing I have to say here is that one of the things Judge Chutkan has been very effective at so far is sort of threading the needle so that there can't be an accusation of bias on appeal with regard to her rulings. And so one of the things that I think is really key here is that the more nuanced this order is, the less likely it's going to be overturned. And that, of course, is something very significant right now because we want Trump to not be able to threaten the prosecutor or his wife, right? We want Trump to not be able to threaten the witnesses and claim that General Milley should be executed and make all sorts of accusations about Bill Barr, right? But broad accusations about not being able to get a fair trial because of the people of DC being blue, I have always had a moment where I thought that was probably the weakest part of the argument. So again, this does not surprise me. This seems to be actually quite a reasonable needle to thread. I think the more significant part of what we are likely to get on the granting in part, which again, we're waiting for this on the live stream from the reporters who were in the courtroom, is likely to be that there is going to be an order that limits his capacity to issue threats or things that are likely to create terroristic acts in his base. So again, I want to remind you all that, one of the things we want the judge to do here is to issue an order that can't be overturned, that simultaneously meets the moment and deals with the effects of Trump's speech. All right. So this is good news so far as I can tell. Again, I'm really interested to hear what's going to come next because presumably there's going to be additional rulings that come out of this. I'm just going to see what we're getting here really quick. It's fun to do this live with you guys. I hope you're enjoying it. If you're enjoying this and you're getting something out of it, please hit the like button on this. Okay, so the most recent reporting is that she is saying that without a restriction on speech, there's a risk that witnesses can be intimidated and that other future witnesses could be dissuaded from coming forward. That is correct, all right? She is also issuing restrictions on statements about Jack Smith, court and staff, and possible witnesses. All right, this is all very, very good. This is, in fact, one of the things that we expected would likely come out of this in light of what she was saying on the bench this morning. She herself made a statement during the oral argument this morning that she was even less upset about the statements that he had made about her as the judge on the case than she was about the statements that Trump had made about court staff in the New York trial. You will all remember that he posted a photo of the judge's clerk with Chuck Schumer and said, "This is Chuck Schumer's girlfriend," with her face. It was a photo that had been taken at what looked like a meet and greet kind of event in New York. Maybe even just like a passing meeting. And she stated from the bench that she felt that this was one of the most egregious things that Trump had done. So the statement here about limitations on statements about court staff makes complete sense. And actually, it's really very significant. Okay. The judge is also saying that if any party violates the restrictions, she will consider sanctions as may be necessary. And she did not specify from the bench what the sanctions would be. And she's apparently adjourned the hearing, and the partial gag order is in place. Okay. So this is very significant. And, I think that from where we sit right now, my on-the-fly analysis as we are doing this live is that this is all very, 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 very good. And I really want people to understand that what good judges do in very high stakes cases is that they are very precise about their rulings. There's this statement when you're in law school that they teach you that hard cases make bad law. And the assumption is that because when you're in a situation with novel facts that are very difficult to parse, if you're not careful, the result can be that the rulings in a case, or a verdict in a case, or a judgment in a case can go too far and impact other forms of defendants, other cases, and the like. What she has done here is really, really smart, because there's not going to be an argument to be made here that she has impacted his First Amendment rights. She hasn't banned him from talking about anything. She hasn't stopped him even from making comments about the makeup of the District of Columbia in terms of their political positions, all right? And the general way in which DC tilts very, very, very blue, as we all know, all right? But she has limited the statements that are likely to incite violence, intimidate witnesses, constitute witness tampering, threaten the judge, threaten court staff. And all of those things are things that by the way, the local criminal procedure rule that is at issue, as well as, I have to remind everybody, there's binding Supreme Court authority on this that can limit extrajudicial statements in instances where those statements could influence the outcome of a trial. She has followed all of this to the letter. This sounds like it's a very tightly and narrowly crafted order to limit what he's allowed to say so that people's lives aren't jeopardized, trial procedure isn't jeopardized, judges, staff, witnesses are not intimidated. And all of this is really solid. So, I think this is a really positive outcome. And, I think that I frankly, just again, doing this on the fly, this sounds like a very, very smart order here. I'm looking right now at the latest on what we've got here. Yes. Okay. So Trump can still attack the Biden administration or the Justice Department and say that he thinks the prosecution is politically motivated, but he cannot attack Jack Smith, the special counsel, or his staff or family, nor can he attack court staff or witnesses. He can attack Pence, except he can't talk about Pence's role in the events that involved the case. The judge did not say whether she was barring Trump from attacking her personally, which is a really interesting nuance to this as well. Because I have to say that, one of the ways to prevent an argument on an appeal of this order or on an appeal of a conviction would be to say, well, the judge stopped him from talking about her, and that clearly shows a bias, right? So the other thing about this that is profoundly nuanced is that this has prevented, if he attacks her, she's obviously got, she can get security. There can be protection extended to her from court staff, meaning like the bailiffs and otherwise. Obviously she can ask for other protection through the court. But I have to say that I think that not ruling on that, not mentioning that specifically, man, that strikes me as a really smart needle to thread, because it really completely undercuts the argument that she is somehow inherently biased against Donald Trump, or that she's been intimidated by his conduct or his statements against her. So all very, very wise. I have to say that from the standpoint of where we sit right now, I'm really, really, really impressed. And I think that this is a very, very smart move on her part. Very nuanced ruling, very tight ruling. Again, I think the fact that she has not decided one way or another what the sanctions will be leaves room for those sanctions to be everything from fines to pretrial detention. And that, by the way, I think is very smart as well, because what it does is it avoids the argument that Laura was making at the very end of the oral argument that, what are you going to do? Throw someone in jail while they're running for president? Well, she doesn't have to decide that issue right now, because that issue is actually not before her. It will be before her if and when, because we all know how this is likely to go, he violates the order. All right. And at that moment, she will then have the facts before her to decide, and presumably the law, because there would be briefing on it, about whether or not it's within her authority to reasonable decision making to throw him in the clink while he's running for president. But I have to say that, this is all very tightly nuanced. Like, I actually really appreciate this. And, the other thing about this is that it does leave hanging out there for Trump and his attorney the looming possibility that he could be subject to pretrial detention if he violates it. So, this is great. We have 763 people watching live right now. If you have not yet hit the like button on this broadcast, please do so. And please hit subscribe. And please, support this broadcast. You can share this with your friends if you would care to. I'm going to remind everybody that we're here every single Monday, Tuesday, Wednesday, Thursday, Friday at 9 a.m. live Pacific, noon live Eastern. And you can also become a paid subscriber at patreon.com/resistance live to support this work and also to ask questions 2 hours before every broadcast. Thank you all for watching. It's been a while since we had this many people on live. Back in the day, there were days where I had like 2,000 people watching live when we were doing this, like 4 years ago, live on Facebook. But it's so great to see these numbers. I'm really grateful for all of you. I also just want to remind everyone that, this is still an unfolding story. And one of the things that we have seen since the gag order, the initial gag order, which was termed a gag order, was issued by Judge Engoron in New York State after his clerk was threatened, is that Trump actually has refrained from threatening the judge or the clerk or any of the staff in that case. So, I don't want to discount the fact that, Judge Chutkan leaving open the possibility of pretrial detention, like not ruling on it one way or another here, may in fact have a chastening effect on Donald Trump. Like, I have to remind everybody that when we deal with people who are malignant narcissists, one of the things that is the case about the way in which these things are handled. Okay, let me just ban that user. Thank you all. One of the things that's so great about how we stream now on YouTube is that whenever somebody comes on here to troll, I can just get rid of them like that. Okay, one of the things that I want people to obviously be aware of here as well is that one of the things about malignant narcissists is that sometimes it's only the threat of court accountability, meaning like incarceration or other really strict sanctions, that will stop a malignant narcissist from engaging in conduct that is threatening. There's been a lot of discussion about this, by the way, in the domestic violence community. And there's a lot of discussion about it right now in family law circles about the fact that, for instance, when you have a malignant narcissist in a divorce situation, sometimes the only way that they will be stopped from threatening someone, from failing to pay child support and all sorts of other issues is with court intervention that is in the form of orders. And it does actually seem to work in some instances. Now, I know that, one of the things that we see in instances with Trump is that inevitably he loses complete control of himself, right? We've seen instances, even since the order was issued by Judge Engoron, which was much more limited than this one, that he has still gone out of his way to attack other individuals, all right, and witnesses. So the question now is whether or not he's truly going to grasp the implications of this order that has been issued by Judge Chutkan now. And if he does, it's quite possible that we might actually see him not engage in this conduct for the immediate future. But all that said, I'm not holding my breath. Like, we all know when it gets to be like 1 o'clock in the morning and he's mad and he's got nobody else to vent for, he takes to Truth Social like he used to take to Twitter, and all sorts of insane diarrhea come out of his mouth. So I just want folks to understand that we have yet to see what the outcome is going to be here, but this is the strongest potential limitation on his freedom that we have seen so far in this process. And there has been an enormous amount of reporting since this motion was filed last month about the fact that, honestly, he was terrified about the prospect of pretrial detention. So who knows? Again, I always want to hold out the hope that, judicial intervention like this, let alone by a judge who very clearly has had it up to here with what he's done so far, may be enough to stop what he's been saying. I'm not going to hold my breath on it, but, it might. And Goron's conduct actually did something. Now, we know that there was a very strong, behind closed doors, meeting in the middle of that trial when this happened, when Trump was in the courtroom and left for lunch and then posted all of that on Truth Social, that may have contained statements about what Engoron was going to do if it continued. My hope is that Lauro, notwithstanding all of the really not viable arguments that he made this morning in oral argument, is at the moment having a conversation with his client about the implications of this partial gag order. I certainly used to be the kind of lawyer where when I had an adverse ruling against my client, the first thing I did when I got out of the courtroom and into a car was to call the client and be like, okay, here's the deal, and here's what you've got to do, and here's what's going to happen if you don't. So I don't know, well, again, we're going to have to see how this plays out. I personally, I because of my interest in making sure that witnesses are safe and judges are safe, I certainly hope that this order has an effect. And, I know that there's an awful lot of us here who would love to see Trump tossed in jail immediately, right? I get that. And also, one of the things that those of you who have been watching here for the last few months while we've been talking about these issues, let alone the last almost 7 years, one of the things that you all know is that, there is a process by which this judge has had to get to this point and will have to get to further points. Like I've been saying to all of you all along, it's not just he makes one statement and he gets arrested. I mean, he's already been arrested, but he makes one statement and then he gets pretrial detention. It actually is a process by which, especially in a case that is this high stakes, the judge has to evaluate the evidence, right? Has to evaluate the evidence of his statements, has to evaluate the law and how it should be applied, has to evaluate. And there are some novel implications, right? We've never had a situation where a presidential candidate has been facing 91 crimes in 4 different jurisdictions under indictment, right? This is not a normal situation by any stretch of the imagination, but she's got to follow the letter of the law. And one of the things that I do think is really very, very critical to consider here is that she is really crossing the T's and dotting the I's. And that in and of itself bodes well. It just bodes well, because doing what she is doing in the process that she is doing it with a very slow evaluative process, briefing on both sides, not acting sua sponte, which means of her own volition, meaning outside of a motion from the prosecution or the defense. Not that there would be one from the defense, but I suppose they could file a counter gag order. I don't know. But point being, I do know they could file a motion to that effect, but they haven't done it. She is really doing a very careful evaluation process here, threading the needle, limiting this in very significant ways. And what that means is that then if he does break this order, if he does violate this order, and the moment comes where there is a motion filed for pretrial detention, the record will be full of evidence that justifies it. And again, I want to remind everyone that one of the things that she did this morning in the oral argument was she read into the record all of Trump's statements so far in various categories. Statements about the citizens of the District of Columbia, statements about the judge, statements about the prosecution team, Jack Smith's wife, other prosecutors that are involved in the case, and statements about witnesses. And so the record has been built of his already threatening, intimidating, witness tampering, jury tampering conduct, right? And so one of the things that means is that in the event that he does engage in additional threats, there will be an incredible record of evidence to support a pretrial detention. And I do just want to, mention to folks that even if she is being this careful, there could even be an intermediary step, which is that, he does something that violates the order again. She fines him for $250,000 or something along those lines. And then we've got another violation, and that's the one that lands him in pretrial detention. So, again, I've said this a lot here lately, but, we've got 843 people here live right now. So many of you may not have seen the earlier broadcast where I talked about how the escalation of this has to work. We want her to issue a pretrial detention order that is unappealable, right? That is not going to show bias of the judge, that could potentially poison any future conviction. All right. So we want her to be very, very, very careful. And again, doing it in this methodical way that she has done it with a very tight limitations that don't in any way, shape, or form impinge on his First Amendment rights, because the next thing that's going to happen is people are going to be running around like claiming that this violates the First Amendment. It doesn't. But one of the things that I do want people to just consider here, I don't want anybody watching to be surprised if he violates the order and the next step is fines. All right. Now, again, I got to say, this order does not state at this time what the sanctions might be. All right. And so we would have to have future hearings on this, future briefing. She would have to consider the law to be applied. She would have to consider the various ways in which a pretrial detention could implicate things like running for office. And again, that doesn't mean he wouldn't be subject to pretrial detention. That's the other thing I have to point out here is that, she was so adamant in this oral argument this morning about the fact that he's not above the law, and that any other defendant who had done some of the things that he'd done probably wouldn't be walking around, right? So there's even an argument to be made here that she's been more generous with him. And that, by the way, is a good thing. I know there's a lot of us who, again, I want to point out, have been here for a very long time, and who have seen all of this through the lens of watching him do things and not be held accountable. But I also just want to remind people of something like really, really important here, okay? And it's that, again, it is a novel circumstance, and it is a circumstance that we've never seen before in American history. And so her extending, a little bit more room here than she might to any other criminal defendant, meaning like, ordinarily, if you were calling the prosecutor a thug, as she pointed out, you probably wouldn't be walking around anymore. The benefit of her not just like sending him to the clink right away for that is that there is not an argument to be made that she's like mistreating him in some way, or that she's not accounting for the fact that he's running for president. There's not an argument to be made that she's violating his ability to campaign or anything like that. So, I truly see this as a really smart ruling. And I'll also just say that, having appeared a whole multitude of times in the district court for the District of Columbia, albeit not in front of Judge Chutkan, because she didn't take the bench until after I had stopped practicing full time. I have a lot of respect for the way in which she has handled this as a jurist. And my experience in the district court of the District of Columbia was that when you came up against a judge that was this tough, and this overt in an oral argument about your position, as overt as she was with Lauro here, with Trump's attorney, you should expect that you're kind of like in very bad shape. And so the fact that she has even engaged in like a nuanced position here, meaning like, there are certain things he's going to be allowed to say, is also something that I think actually is a very favorable argument. In the event that like Lauro at some point makes an argument that the judge is biased or asks for recusal. We haven't seen that yet. Or there's an argument after he's convicted on appeal that she did something wrong. Like fundamentally, she's really undercut that completely. This is a really good question, Jen. Do I think this ruling will influence other judges? Well, it's not supposed to, all right? So there's nothing about this ruling that is precedential from the standpoint of the other trials or cases that are going on, all right? Like the district courts are on the same level. So a circuit court of appeals decision would arguably be it is controlling authority over the district courts in that circuit court's line of command, so to speak. But when you've got, say, Judge Eileen Cannon in Florida and Judge Chutkan in the district court for the District of Columbia, they're peers. Those courts are peer courts in that way. So a ruling like this would be considered persuasive authority. It wouldn't be considered controlling authority. And it has no bearing whatsoever on what happens in the state courts, because they're completely different. You all know, like when I've put on my former Columbia Law School professor hat here and talked about the triangle of the way in which our judicial system works, state on one arm, federal on the other. It's not like the federal courts are like on top of the state courts here in terms of how precedent is applied. They run in a triangle that meets at the Supreme Court of the United States. All right. So I will say, though, that, in the event that he's indicted in another federal court, or there's an argument to be made in Cannon's court, which there isn't going to be because he likes her, right? But let's just say hypothetically he attacks Judge Cannon. The ruling that Judge Chutkan just made would be persuasive authority for Judge Cannon to issue a similar order. It would not be controlling authority. All right. So Cannon could consider it. could say that, the same rationale applies here as applies in the district court for the District of Columbia, but it would not be controlling. She wouldn't be required, in other words, to follow that case as controlling law. All right. So, one of the things that I think we have to consider here, by the way, is that there is a very big difference in terms of how these cases are being handled in other courts, right? And Judge Engoron in New York State Court has already issued a limited gag order for purposes of his courtroom with regard to court staff. He hasn't said anything about witnesses yet, right? He hasn't done anything about the claim that, all the horrible claims that Trump has made about Tish James, right? All the racist nicknames that he has applied to her while this case has been pending and while the trial has been ongoing. There have been no limitations on that. Jim, I speak fast. If you don't like it, the great news about this is you can go back and watch the replay. All right. I'm a former federal court trial lawyer. I think very quickly on my feet. All right. And that's the way it goes. So one of the things that, I do want people to kind of consider here in all of this is that we do have competing interests in some of these cases as well. Right. We have a judge who has been threatened and attacked by Trump. We have someone who was actually arrested for threatening to kill Judge Chutkan as a result of the statements that Trump made. Very different posture to what has happened in Cannon's courtroom in the district court in Florida. Also very different posture, even with regard to Judge Engoron, who he has claimed is like a Democrat judge and is a part of like some Democrat deep state thing. One of the things that I do also want people to kind of consider here is that we have a trial that's already underway in New York State that concerns only civil allegations, right? The case that Tish James and her team are litigating in New York is about Trump's financial fraud and his insurance fraud and his bank fraud, right? The implications, they are significant to him in terms of his malignant narcissism, right? Because they are a threat to his ability to run his businesses. We know that, there's already been this order that has stated that fraud has been proven, and his businesses are subject to the corporate death penalty in New York State. And so the implications there are significant to him, but they're financial implications, they're business implications, they're brand implications. And of course, when you're a narcissist and you've claimed to everybody that you're wildly rich and evidence is being presented day in and day out in a courtroom that shows that you were lying about it all along, yes, that's going to impact your narcissistic supply and your perceptions of yourself and your brand. But it's not as serious as a threat as potentially spending the rest of your life in prison, dying in prison, right? And so to a great extent, I think the considerations here, particularly with regard to the gag order and the statements that he's made about witnesses and about the prosecutors in Jack Smith's case, have a greater implication in my mind, if we're looking at hierarchy, because they are arguably interfering with a prosecution that could land him in jail, if that makes sense. Now, I'm saying this from the perspective of perception, not necessarily the perspective of like legal analysis, but I've appeared in all of these courts, right? Like I handled cases in the district court for the District of Columbia. I'm a DC licensed lawyer. I'm a New York licensed lawyer. The vast majority of my practice in New York was in, the Southern District of New York. Of course, this is in New York State Court, Tish James's case, but I've appeared in that court as well, the Supreme Court for New York, which is the trial court level there. I understand the inherent workings of these courts very, very well. And at the same time, I think that there is there's an important thing here about strategy on gag orders and also about how Trump's own response to that, to what's happening to him, that everybody should sort of understand. Yes, I am aware, Rose, that there's a hold on the receivership right now in New York State currently that is pending an appeal of that order. All right. So, I want everybody to, be very, very clear here that, there's a number, an extraordinary number of moving pieces at this point, which is one reason why we're live here every day at 9 a.m. Pacific, 12 noon Eastern. The overlapping legal issues here are incredible and are going to continue to be incredible. Because reminder, I said it at the top of this broadcast, but the criminal trial of Sidney Powell and Ken Chesebro starts a week from today. While we're talking, Judge McAfee is ruling on questions that are going to be included in the jury questionnaire as of Friday. right? Because the jury starts being sat on Friday of this week in that courtroom. And the other thing about that, Fani Willis's trial is that we're going to hear an enormous amount of evidence in that regard. And, where we get to at that point, with regard to other defendants pleading out is going to be a real issue. By the way, I just have to point out in Fulton County, we haven't talked about this yet today. Nobody should be surprised if we have a guilty plea from Ken Chesbrough or Sidney Powell between now and next Monday. All right. Because we know that it's usually on the courthouse steps that people start to get afraid that they're going to spend the rest of their lives in prison. And so I would really not be concerned about that if it happens. And honestly, it would be very, very bad for Trump and for the other witnesses. We already know that Scott Hall has taken a guilty plea, and that in and of itself is very concerning. So bye. There's another one. Love being able to ban users in real time. To answer the question about whether or not he can hide cash or properties, the answer to that is no. We've talked about this on the broadcast quite a bit over the last 2 weeks. We've talked about the issue of what's called fraudulent transfer. In most jurisdictions, transferring assets or cash to evade liability in a civil matter is a crime in and of itself. And there's already an order in place in Judge Engeron's courtroom that says that you are just so funny. It's really funny seeing all these people pop in here all of a sudden with your trolley comments. Like I can't just snap my fingers and say, see you later. One of the things that I will just mention here that is very significant is that there's an order already in place in Judge Engoron's courtroom that says no assets can be transferred of any kind by the Trump organization, Trump himself, Junior, Eric, Weisselberg, any of the other defendants without approval of the court. Okay, so the likelihood that there is going to be any transfer of assets that is not subject to that order is zero. And if they happen to try to do it anyway, the court's going to know. Reminder, Tish James has already brought before the court that they tried to set up this shell corporation in Delaware called Trump Organization 2 that was designed to kind of take assets. So the court's already keeping an eye on this. So I'm just optimistic at this point. And I think, that's one of the things that's really good about where we are today. It's one of the things that's really good about these judges doing their job, doing it very well, doing it right. And, I am really interested to see where this goes. I'll just point out before I go that right now, the New York Times is reporting on the fact that Trump has 2 campaign events today in Iowa, and that accusing federal prosecutors of politically motivated prosecution is one of the features of his stump speech. So we're going to get to see in real time whether or not he is going to continue bashing the prosecutor, bashing the prosecutor's wife, bashing the judge. Because if he does that, we're going to have a problem. I mean, literally last night, as the New York Times is reporting right now, Trump called Jack Smith leaking, crooked, and deranged on Truth Social, which if he does it right now, will be a violation of the gag order. And final point today, and then I'm going to go. I want people to just consider one other thing here, all right? And it is this. It is that, we need a functioning judiciary, both federally and state-wise, to prevent rising fascism in America, all right? And it's one of the reasons why if you don't have the federal bench, you have nothing, all right? So you all know that I usually like to end these broadcasts by reminding people that democracy doesn't work unless you work it, okay? The future of our democracy is dependent on all of us doing the work of getting out the vote, campaigning on issues that we care about, talking to our neighbors and our friends whenever we can. And the way in which judges are seated is through the United States Senate. So one of the things that's really great about what we've seen from Judge Chutkan this morning is that she is fair and balanced and impartial. Nobody can claim otherwise on the basis of this very nuanced, tight order that she's issued. And the way in which we get judges like her on the bench is by electing the right officials to Congress, right? Electing the right presidential candidate, meaning Democrats who actually care about seating qualified jurists to the bench, of which Eileen Cannon is not one. We all know this, right? When she was nominated by Donald Trump, there were whole debates about how unqualified she was. She'd never tried a case. So I really want folks to get very, very clear on the fact that elections matter not just in terms of the presidency and, the makeup of the House and the Senate, the issues that we're facing right now with the Speaker of the House, which I talked about earlier in this broadcast. All of this is ameliorated by getting out the vote, by doing the work where you live, by having conversations at your kid's baseball game or outside of your tennis match, or, you know, whatever you're doing in your day-to-day work. I've talked a lot here about how I'm constantly talking about politics with my checkout people at Trader Joe's. It's really, really important that you need to do that. You do that work wherever you live and however you can. It's also really important right now that you get involved in your local elections, because all the harm that we're seeing to the country right now is not just happening at the federal level, it's happening at school boards and environmental protection boards and on city councils and county councils, in state legislatures. That's where all these horrendous anti-trans bills are passing, these anti-education bills. So it's just really, really critically important at this point that we do the work for 2024. All right. I've talked a lot on this broadcast already about Jim Jordan and what he's doing and the ways in which all of this is moving. So you can go back and watch the broadcast from the beginning. I really encourage you to do that. We've had, at my highest count today, 1,065 viewers here live. I'm so grateful to all of you for being here. If you have not yet smashed the like button below this broadcast, please do that. Please hit subscribe. We're here 5 days a week right now. And also, if you found this useful, I would greatly appreciate it if you would hop on over to patreon.com/resistancelive and become a paid subscriber over there. A subscription started as little as $2 a month, which is less than a dime a broadcast. And every subscription helps to support myself and my team behind the scenes who manage all of our technology here. And also, you get to join us for Progressive Coffee Hour every Sunday morning, which is rad and awesome. And you can also ask questions before every broadcast. There's a question feed that goes live 2 hours before every broadcast, and that I will answer on the broadcast itself. All right, that's it for today, guys. It's been a great time doing all of this live and real. I'm grateful to all of you for being here. Thankful to all of you for all the work that you're doing where you live and in your own communities to sustain our democracy and make sure that we continue to win. And let's see how Trump responds to this gag order. For the person who asked, yeah, I think we can call it a gag order now because the judges called it a gag order. The reason why I don't like that language, just to reiterate, is because his speech is actually not being limited. What's being limited is his threats and what actually is criminal activity in terms of witness intimidation, threatening federal prosecutors, which is a crime, intimidating witnesses, which is a crime, interfering with jury selection, which is a crime. What is being limited is statements that qualify as criminal activity. All right, my friends, I will see you all back here live tomorrow at 9 a.m. Grateful to all of you. I will see you all online in the interim. If there's any breaking news this afternoon, you all know I'll be happy to do an emergency broadcast. But lots of love to our supporters and our followers here. Thanks for being with me live on the air while we did this, and I'll catch you all here tomorrow. All right, take care, everyone. Bye.